0122, Town of Florence versus Arizona Department of Environmental Quality. Each side does have 20 minutes for oral argument. If you wish to allocate your time within that 20 minutes, that's up to you, but that's your call, not ours. If appellant wishes to reserve time for rebuttal, you're free to do that, but you'll need to keep track of your own time at the podium clock. Out of respect for our attorneys when they're presenting their arguments, I would ask everyone to make sure your cell phones are off. That way we won't have our proceedings interrupted and we'll avoid any embarrassment that might result as well. We have reviewed the record. We have conferenced the case. We'd encourage you to keep that in mind as you present oral argument to us. And please also, when you step to the podium, tell us your name and the party that you represent. Our proceedings are being recorded and will be posted for broad consumption after our proceeding today. But with that, Ms. Bourne.
Been enacted by our legislature that protects our groundwater when ADEQ has issued a permit to someone that gives them the authority or the legal right to pollute an aquifer. In this instance, and I know the court has read the briefs, one of the things that I think is very important in considering the posture of the case is to realize that we did have a 36-day hearing that resulted in an order by the ALJ judge that was then accepted almost in totality by the Water Quality Review Board. And in the Water Quality Review Board order, which actually attached the ALJ order, it remanded the case to ADEQ and asked ADEQ to make the amendments consistent with the order. And it is our position that that language meant that when ADEQ went back and worked the permit out with Florence Copper, it needed to do so respecting the findings of fact and conclusions of law of the ALJ judge, and that did not happen in this case. In paragraph 9 of the 2017 Water Control Board order, you will see that it says that ADEQ proceeded with the permit during its normal procedure. It actually did a significant amendment procedure without any reference at all to the requirements of the ALJ order that had been previously accepted by the board. As a result, when the significant amendment went through and then was appealed to the board, you can see in the board's 2017 order that it finds that appellants did not meet their burden of proving that ADEQ was arbitrary, unreasonable, or had acted contrary to law in approving the 2016 permit for Florence Copper. The problem there is it switched the burden of proof back onto appellants when appellants had already proved in a 36-day hearing that the compliance wells were in the wrong location. And I want to caution the court, there's some language in briefs about there being new wells, that there were new compliance wells. There are no new wells from the judge's 2014 ALJ order accepted by the board and the 2017 order. The compliance wells are the same.
There was a change in the location of the 254 wells that were always going to be installed near to the well field. Those were changed slightly, 60 feet or so, right?
There was one movement of one of the wells, but you can see, and in our briefs, you know, we put the 2014 and 2016. You can also see where the wells are in Florence Copper's brief. They depict a very similar position. But what they didn't do was move those wells any closer to the injection site.
They didn't move them closer to the injection site. But isn't it true that the statute links the validity of the POC wells to the location of the PMA? And in the amendment, what Florence Copper did is come up with 2 new PMAs, one surrounding the well field, one surrounding the ponds. And isn't it so that the 2 54 wells, the 2 wells yet to be drilled, are almost at the border of the well field PMA?
I want to first say to the court, those wells were drilled in 2014 prior to the ALJ proceeding. They actually existed at the time.
Okay.
And that's why when we call them new wells, I want people to realize, the
Well, they
court
weren't
to
old
realize,
wells.
they were, that they were actually there when the ALJ was evaluating whether or not they were in a position that complied with the law. The PMA and the issues with the PMA, because if you look at 49-244, what we're trying to do is we have that project management area, and within that is the PTF, right? The place that they're actually injecting these solutions. All of the evidence before the ALJ judge and consistent with the evidence before the Water Appeals Board in 2017 is that no one ever expects those pollutants to move more than 100 or 200 feet from that area. So the statute is saying you have this area where you're allowed to pollute. It's the area in which you're working, you have your injections, you have your recoveries, and you have to prove that outside that area, at the limit of that area, you haven't polluted. So we have this situation, it's very interesting because again, the evidence never changed. 11 and a half years it will take to get to the point of compliance well. So the question becomes, really, why does the permit there's table 4.1.7 and other provisions in the actual permit, 2.7.4.4, where ADEQ is requiring Florence Copper to monitor on a quarterly or semi-annual basis these compliance wells, where we know that even if there was an event today, no effluent would show up or pollutant would show up for 11 and a half years.
But that calculation of 11 years doesn't, as I read your brief, that applies to the 4, I'll call them old wells, the old POC wells, the wells that are almost on the land, on the border of the parcel. But what about the 2 wells that were installed in 2014?
In the 2 wells that were installed in 2014, there is no evidence, and the ALJ found to the contrary, that during the 7 years of this permit, the 2 years of the working permit and the 5 years where they had to continue to test to show that there is no pollutant outside of the PMA area, during that 7 years, that none of that pollutant could make it to either or any of those 6 wells.
I didn't see that the ALJ treated those 2 wells separately.
Well, and one of the easiest ways maybe to answer the court's question is to look at what the board actually said in 2017. If you look at the March 6, 2017 transcript of the proceedings before the Water Appeals Board, at pages 92 to 98, the board member, Ms. Clements, is asking questions of the ADEQ representative. And she says here, I understand the various testimony and what I've read in the record. The probability that anything would escape and actually reach one of the point of compliance wells is, especially during the lifetime of the operational permit, is negligible. The board knows at the time of the 2017 hearing that the wells are still in a place that during the course of the permit, that no pollutant will reach there even if it breaches the PMA. You can also look at page 109, I believe it is, where another board member goes through pages of questions where he is asking ADEQ to explain why it's okay that the wells are so far away that during the permit period, you will never actually be able to determine whether any affluent is moving or pollution is moving in between the two areas. And so I think when the court looks at the record, if you look at the same proceeding, the March 6, 2017 proceeding, they're still saying that this pollutant is never expected to move more than 100 or 200 feet.
But we look to the statute, and as to the two wells, the wells that were installed in 2014, I mean, aren't those at the sufficiently close to the newly designated wellfield PMA?
They have the newly designated PMA that the court needs to realize the facts about the PMA have not changed. They have the PTF where they're putting the effluent in, and somebody says, we're never going 100 to 200 feet beyond that. And then they have said, we are going to operationally make a cone of depression that goes all the way out to 500 feet so that we can bring our PMA out to the wells. And what our position is that's not how you evaluate whether your wells are in the correct place. Because we have then a situation where there's not supposed to be any pollutant from 200 feet all the way out to the end of this cone of depression. And they try and say under the statute that your dike or your barrier is included in the PMA, but that doesn't take into account that there is this 200 to 300 feet space that everybody agrees is not supposed to be polluted before they actually are having their cone of depression. So they've moved it to the wells instead of determining where it is that they are actually polluting and then putting the wells right outside of that area. And so the situation that arises is what you can see again in the conversations of the board at pages 92 to 98, and what occurs after page 109 is that the board knows that there is no way that we are in a situation where the pollutant will ever travel to one of these point of compliance wells during the course of this permit. And the reason why they accept it is you will see what they start talking about is monitoring. And you can see it in Florence Copper's brief. They say the point of compliance wells are irrelevant to this PTF. They say as long as we are monitoring within the PMA, that's what's important. And the statute does not say that. In the PMA...
The statute, though, doesn't have any standard at all to apply. I know there's a dispute in the briefs about the ALJ's reference to meaningful monitoring. The statute doesn't say meaningful monitoring. Given the fact that at least I can't find in the statute anything other than it can't be X feet from this or Y feet from that, these alternative POCs, didn't the board, I mean, how can we say the board abused its discretion or acted arbitrarily given the much more fulsome mandated hydraulic control, mandated monitoring in the new monitoring wells and so forth?
Two reasons. One, Your Honor, is because there is a non-appealed decision by the ALJ judge that says meaningful monitoring is required as a matter of law. She says that at, I think, somewhere between paragraph 50 and paragraph 61. I think it's in 61. And Florence Copper never appealed that. And so we're in a position, again, where the town is disadvantaged because we are ignoring the fact that there were actually findings of fact and conclusions of law that could have been appealed, that were not, that now we're just saying none of the law that the ALJ judge decided is important. So that's number one. Number two
Counsel,
is...
before you get to number
yes.
two, and I want to hear you on number two, but doesn't your law of the case argument turn on the thought that the record on remand didn't change? It's the same record? And if it's a fundamentally different or even materially different or record, does law of the case still obtain?
Whether you call it law of the case or whether or not you say that there has been a non-appealed finding of what the law is in this case, The changes that were made related to the project management area and the monitoring and activities that were going on there. And I can't stress enough to the court, that is the place that you expect to find pollution. But what we know is the statute requires that they prove that or demonstrate that the pollutant did not get out of that PMA area. They're required to demonstrate that under the statute, under the ADEQ guidelines. And so we're in a position where the record is not contested that if there is a breach of the PMA, no one will know for 11 and a half years.
Well, keep coming back. I mean, isn't that obviously not true, given that the two other wells are much closer to the PMA?
Again, when the court made that finding, and I think it's at paragraph 333, that it's 11 years, she has all 6 of those wells when she makes that finding. And so that is what the testimony is. And again, the effluent is not expected to go more than the 100 or 200, and everybody agrees that it moves at about 75 feet a year. And so once they increase that PMA out to 500 feet, it means that now you actually have pollution of an area that's outside of where you're injecting that for 1 year, for 2 years, before it gets to your edge of your cone of depression and outside of your project management area. And what we're saying is if the statute requires you to prove that, that you have not polluted outside that project management area, then you need to be able to demonstrate that within the life of the permit. And I can say, Your Honor, part of the reason why the analysis about the 2 wells being closer is not so is because Florence Copper argues in its brief that the compliance wells are meaningless. That's what are meaningless. They argue in their brief that they're meaningless to the success of the PTF. And that is not true, because the compliance wells, and you're focusing on these 2, the compliance wells are designed to make sure that that pollution is not going somewhere that it's not supposed to go. And if it was going to be at that location at a reasonable period of time, then Florence Copper would be arguing that they complied. But what they argue in their brief is that the compliance wells are not for the purpose of monitoring. And we agree with that. There's all this monitoring going in this PMA area, and all of the changes during the substantial amendment process were to the PMA area, and you can actually read the discussions of the board members where they say, I am really concerned about how far away these wells are, but I'm not worried because they're really monitoring. They talk about this is the most monitored piece of property. They're not talking about the compliance wells, they're talking about within the PMA. What we're saying is it violates the law for the board or Florence Copper to be arguing that as long as you have really great protection within the PMA, then you don't have to comply with the law with respect to the compliance well.
I'm sorry, your time is running
yes,
out, but under 49244, what is the standard by which the board assesses a proposed alternative POC?
The alternative POC has to do, first they have to show that there's some reason why they need an alternative. Here, the ALJ judge found $377,000 was the expense, and the ALJ judge found that that did not justify moving the wells or changing the position, and nobody ever appealed that. And then we get to in front of the water board in 2017, and they say exactly the opposite. Even though they had accepted those findings of fact and conclusions of law previously, that $377,000 was not enough in this grand scale project. I also would say to the court that this project and the is novel. That's the term the court uses, or the ALJ judge at 62. This is a novel project for ADEQ. And I only have about a minute left that I'd like to reserve if I'm allowed to. And
You may. You may. Thank you, Counsel. Counsel, who's drawn the long straw here?
May it please the court, my name is Jeff Cantrell. I'm with the Attorney General's office and I represent ADEQ. My plan is to speak for about 10 minutes and I'll be sharing the time with Brad Glass, my co-counsel here. He represents Florence Copper. Excuse me. This appeal deals with and surrounds a temporary aquifer protection permit that was issued first in 2012, 8 years ago, and by its very terms expires in December of this year. At the same time, Florence Copper has acquired an EPA-issued UIC permit, which is a similar regulatory program, and that's mentioned in the current APP permit at sections 2.2.3 and 2.2.4.
It needs both to do the project.
I'm sorry?
It needs both permits to do the project.
Yes. Okay. I plan on addressing three areas: the law of the case, the POC, PMA, and finally the fluid electroconductivity questions that were raised.
In addressing the law of the case, will you focus, please, on the fundamental truth that the amendment did not change the well field. The amendment did not change where the injection wells are, where the recovery wells are, and it didn't effectively change the locations of the POCs. So, that being the case, other than the sleight of hand of moving the circles defining the PMAs, why shouldn't the original ALJ ruling, which was endorsed by the board, control?
As the Dancing Sunshine Lounge case held, is that when there's been a change in facts, change of evidence, then law of the case is not applied. Law of the case is a judicial doctrine, and Dancing Sunshine even said that when there are changes of fact, it should be very reserved or not applied because of that.
So what are the facts that changed?
So the facts are is that during the amendment procedure, so in other words, after the 2014 board decision, ADEQ requested Florence Copper to submit additional information to resolve the questions it had. There were 5 additional submissions of facts to ADEQ in response to its questions. And in addition, there were over 20 major changes to the permit that was made in response to those changes of facts. The support on that is our answering brief at page 9 for the additional submittals, and Mary Beth Greenslade's affidavit, pages 3 to 5. In addition, in our answer, we spell out in a tabular form on pages 14 to 16 the 20 major areas and changes in the permit, and as an additional bit of evidence at the board, in our answer and motion to strike, we included a red line strikeout copy of the permit as existed in 2014 and as it was issued, which clearly demonstrates the scope and the nature of the changes in the permit.
Is it true that those changes, the company and the agency would contend, required a cone of depression that would maintain hydraulic control over
Correct.
the contaminants, and supplemented by a long shot the monitoring wells that were going to measure any exceedances?
Yes, the cone of depression did not exist in the 2014 version. It was added in the 2016, and there was a tremendous amount of increased monitoring that occurred through the fluid electroconductivity and bulk electroconductivity requirements that did not exist. Those are 2 big areas, not just changes in fact, but major changes in the sampling and monitoring scheme of the permit that substantially altered the permit from 2016 from what it was in 2014.
But looking at the statute at 49244, I say again, the location of the injection and recovery wells didn't change, and the location of the POCs effectively didn't change.
Well, I know that two of the POCs, we have the old existing 4, which didn't change, but the location of the 2 did change a little bit.
60 feet
but,
or so?
But the definition that actually segues nicely into point of compliance and pollution management area is that the point of compliance wells are statutorily defined. And there's been a lot of talk and a lot of dispute on the monitoring that the POC wells give. But there are two different types of monitoring, and it depends on the information you want to get. There are the monitoring and observation wells, which provide information to the permittee on how their process is operating so they can manage it. And then there are the POC wells. POC wells are defined as the point beyond which no pollutants can move. That's in 243B3. And it's the point at which compliance with the aquifer water quality standards is measured. So it's much like driving your car. You have a water temperature gauge and you have a speedometer, but you don't look at the water temperature gauge to see how fast you're going. The purpose of the POC wells and the purpose of the monitoring wells are completely independent. In addition, in 49.244.1, the point of compliance wells are placed at the limit of the pollutant management area. And when you think about that under the statutory definition, the POC well location is really a function of the PMA. So when the PMA changes, what may not have been acceptable POC well location in 2014 could very well be an acceptable position today, especially when you consider that the point of depression and all of the additional monitoring that's occurred.
But the four older POC wells, those were alternative POCs under the statute to begin with, and they remain alternative POCs under the amendment, meaning they had to satisfy subsection 2 of the statute.
Right.
So what standards does that statute authorize the board to authorize or require the board to impose on such a well other than 350 feet and 750 feet, which are met here?
The existing wells can be exempted in as alternative locations if they're substantially less expensive, require substantially less money investment up front. And Mr. Glass, I expect, will probably be addressing that. But I know that to replace those wells, just the cost of drilling the wells, my understanding is that it's like $300,000.
It costs a lot of money to drill a well. Get past that. Beyond that, it's more expensive to drill new wells. What does the statute tell us about how the board is to assess whether a particular POC that's located as here, way far away from the well fields, is sufficient?
Well, I think the question isn't really one of the distance from the well field. I think, first of all, the board is technically competent. It's required under statute that board members have a high degree of technical competency. During the hearing itself, there was all the parties had their technical experts provide written affidavits, written rebuttal affidavits, and the board itself interviewed or cross-examined those experts and explored all of these areas. There was clearly a substantial amount of evidence in front of the board concerning that. The statute doesn't say that there should be X percentage of the total project cost devoted to wells and so forth. That, I believe, is really left to the discretion of the board, considering especially the fact that the board is technically competent. They understand wells, they understand projects. This is their field. So I'm not sure if that answers your question, but it's what appears the statute says to me.
What evidence was there? Are you going to talk about the electronic conductivity?
I was planning to go to the fluid electroconductivity next.
Explain. We have read the testimony by the experts. What data was before the board to support Florence Copper's proposition that as the lixiviant moves beyond the recovery wells, if it does, it will increase in conductivity if it is moving through fractures and doing its thing with the metals?
I'm glad you asked the question. That the conductivity of the groundwater, which is really what's being measured, not the lixiviant, is a function not only of the concentration of the acid, but is a function of the concentration of the various different minerals that are dissolved by the acid. And during the oral argument and the hearing, board member Fred Brinker, he apologized to the lawyers and stated that they're engineers and they want to know how this works and so forth. So the lawyers would just have to sit down and wait while he explored it. That was on the trial transcript, pages 31 to 32. He also said that it's a very sophisticated, very high-level math was involved in the electroconductivity determinations. Again, that was at the transcript at page 116. So the information that the board relied on was not only the direct discussions between the board and the experts, but also the affidavit of Mark Nichols at 5 to 6 and 1516, Mary Beth Greenslate's affidavit, Exhibit A, and her rebuttal affidavit. Fred Brinker, board member, also stated, he said that there's a ton of monitoring in this thing, so I think that the issues here have been appropriately discussed. That was the transcript at 159. So there was a lot of facts before the board which would support their decision.
Were there any bench tests or any data that Nichols or Greenslade? What's the woman's name?
Fred Brinker?
Greenslade.
No, the other expert.
Oh,
Greenslade.
Mark Nichols, or Mary Beth Greenslade.
That's it.
Yes.
Did either of them cite, or did the application contain any data that would show how that happens?
There was a fairly large amount of discussion between Mr. Brinker and I believe Mr. Nichols
And we've read
about
that. And
about the
that
modeling.
does not reference data. So I'm wondering, data for the proposition that the conductivity will work as your side's expert says, as opposed to these guys' experts say.
Well, I think the only data is the modeling, because it would have been illegal for Florence Copper to inject lixiviant into the ground prior to having its permit, and they couldn't do that until the permit was approved, which happened in December of 2012, and then through the appeal process. So I'm not sure there was actual physical data, but there was modeling. But I do know that Mr. Glass will probably speak about that as well, since it was his experts who developed the model and so forth. And I will yield the remainder of my time to Mr. Glass. I would just say that because of the substantial evidence that was before the board, that we would ask that you approve the permit. Thank you.
Thank you, Mr. Cantrell. Mr. Glass.
Thank you. May it please the court, my name is Brad Glass and I represent Florence Copper. On that last point, I point to the record at 21, which is a brief outlining of the changes that were made in the significant amendment, and the attachments include the application that Florence Copper submitted to ADEQ after the remand was issued. That explains detailed explanations of the different monitoring. It also shows exactly why those alternative points of compliance comply with 49244-2B. And regarding the standard, the statute has specific requirements that you must show the volume and characteristic of the discharge. You have to demonstrate that the Vado zone can handle the discharge, and those points of compliance can't be beyond 750 feet, beyond the property boundary, and they can't be a place where there's a reasonably foreseeable drinking water source. All of those are made in that application, which the agency then took, asked questions, processed, and concluded they were appropriate.
My request for data was intended to get to data to substantiate Mr. Nichols' testimony that if we have a situation where there are unanticipated excursions beyond the recovery wells, by definition, because of the science, you're going to have a higher level of electronic conductivity at that location than in water at that location than you would in the injection wells.
Correct. It's greater or
Yeah.
equal to or greater than. And let me explain. There were 14 new types of monitoring that was added to this permit on remand as part of the significant amendment. This is one of that 14 comprehensive system, and it's got a very specific purpose, which is to detect short circuits or direct releases of the lixiviant in the injection to the observation wells. And that's why it's set the way it is. In theory, it will work. In addition, there's all sorts of monitoring. I take issue with something council said, is they talked about the points of compliance never detecting any pollutants. First of all, points of compliance are, if you design the facility correctly and you comply with bad cat, points of compliance are never impacted. 49244 does not have any temporal requirement in it. And the additional the monitoring that was added by the significant amendment will detect any release from the well field well before it will get to a point of compliance. Now, as to the question about the 2014 decision and how the well field didn't change, the PMA didn't change, I point to page 44 of our brief, and we cite to page 139, lines 4 through 10 of the ALJ decision, where she held, in its application, FCI did not commit to operating the PTF with any specific net rate of recovery or state that any specific cone of depression would be a bad cat control mechanism under ARS-49243B1 and the regulation. Therefore, she concluded that the PMA was a post hoc rationalization and it was first asserted at the hearing and not a permitted control mechanism under bad cat. On remand, the cone of depression was built into the permit. We provide you citation on pages 10 through 12 of our brief, including specific citations to the significant amendment, where the 500-foot cone of depression was built in. And then if you go back to 49244, which talks about how you cite POCs and how PMAs are determined, it's a two-step process. First, you determine the PMA, and second, you then cite the POCs on the boundary of that, or you can use an alternative. I point to there's three sentences when you establish a PMA. It includes, the pollutant management area is the limit projected in the horizontal place on the area in which pollutants will be placed. That's the injection and recovery wells in this instant. The next sentence is the critical one. It says a pollutant management area includes horizontal space taken up by any liner, dike, or other barrier designated to contain pollutants in the facility. And ADEQ has a manual that tells you when you do a specific kind of mining what control techniques or what bad cat you have to use in that facility. And this is not a novel or new mining technique. The manual addresses it. It has in situ mining in the manual, and it says if you are going to undertake this kind of activity, you have to establish a cone of depression, and it has to be built into the permit. Here it is. The significant amendment requires Florence Copper to establish, maintain, and monitor a 500-foot cone of depression. It was built into the PMA because it's required. Two of the POCs, which were new POCs, they were not considered by the ALJ prior, the M54.
They weren't considered? They weren't in the original plan?
They were in a different location. They're not in the location they are now.
Well, they're only 60 feet away, right?
They are. But if you look at, and the reason they're moved is if you look on, we provide you maps that show.
But the ALJ did consider their original location.
She did, under the old PMA, which was a large hexagon or a trapezoid looking figure. It has been narrowed from 120 acres down to 39. The barriers are built into the permit now to comply with the statute. And the two PMAs, both if you apply 49244, one, we contend, comply with the statute. An additional point about those wells, those existing 4 wells that are used at points of compliance, those are actually already point of compliance wells for a site-wide APP that exists at the site.
For the earlier one?
They are.
Earlier project?
They are, for the 1998 site-wide project. So they're existing points of compliance who've served effectively for that prior permit, and we believe serve for this one.
What does the statute say about how to assess whether a well that meets the 350 and 750 feet requirements and can serve as an alternative POC, assuming that installing another well in another location is unduly expensive?
I'm sorry, I didn't understand your question.
Installing a well of this magnitude, this location, is prohibitively expensive. We accept, although I wonder if people had spent money on wells, not lawyers, it could have been done. But be that as it may, other than being less expensive, or I should say avoiding a large expense, and being not closer than 350 feet, not closer than 750 feet, what does the statute tell us is the test by which an alternative POC should be approved?
It's very specific. So it says the first step is it has to be substantially less costly. And then there's another part to the statute, to 2B. If you go on, it says that you only can do so if you provide the discharge elements, the VADO zone can handle it.
You've got an analysis, you've got the, okay.
And if it's between the site and the down gradient water user, And it's not 750 feet beyond the PMA. It's not off the site boundary. And it's not a likely location of a drinking water source in the future. So those are the standards. It's not just substantially less costly. It's substantially less costly and we submitted again in the record 21, one of the attachments contains a part of our application that demonstrates we meet all of those different requirements for those alternate points of compliance. See, my time is up. Thank you.
Thank you. Ms. Bowman, we're going to give you 2 minutes. That will sound like not enough, but it's more than your 20. So.
I feel like I have to turn my New Yorker on and talk pretty fast. I do want to direct the court to paragraph 94 of the ALJ's order where she talks about those 2 new wells. And in finding of fact 323, she talks about their distance, and in 333, she talks about the 11 and a half years. So it puts all of those wells there together. I do want to say that it is very important for the court to realize that in the permit itself, the point of compliance wells are vital to maintaining hydraulic control. We can see in the actual language of the permit, if I can find my page now, that it does say that the point of compliance wells need to be evaluated when you're determining whether or not you're maintaining hydraulic control. It's also in the chart that we see at 4.1.8 on the second page of that table. It talks about the cone of depression, and it talks about monitoring the point of compliance wells. So if they're going to say we have this great cone of depression, it's going to keep these pollutants in here, by the very terms of the permit, the compliance wells and what they show is relevant to determining whether or not that works. The issue with respect to cone of depression, I'll throw my right piece of paper here. The issue of the cone of depression was considered by the ALJ. You can see it at 212, 294, 52, 304. There were lots of discussions before the ALJ about the cone of depression. One thing that's very important, at paragraph 291, the ALJ says that ADEQ admits or says it's its position that it can't tell people where to put the point of compliance well. That the permittee gets to decide that, and then they just determine whether or not it's legal, and that they give them great amount of deference. And at page 158, you'll see Board Member Clements, and at page 159, you'll see Hendrick, or the other board member. They talk about the fact that they do not like that these wells are 500 feet away because you will get no meaningful data from them. But they believe that the site, the PMA, is being monitored sufficiently that they're confident that there's not going to be a problem. And you can't have a permit that says you need to look at the point of compliance well to determine whether or not you have maintained hydraulic control, and have a board make a finding that they know that no pollutant will make it to the point of the well, but at the same time they're comfortable because the site is being monitored in the places where the pollutant is expected to be.
Council, thank you for your presentation. Thank you all. Thank you for your briefing as well. It's much appreciated. You've given us much to think about. We will take the matter under advisement. We'll issue a written ruling in due course. Court stands in recess.